All right, welcome Disability Law Show. Just like it says, welcome back this week. I'm John Scholes. He's James Fireman. To reach out to James, Samfiru, Tumarkin, LLP, you can do so anytime to discuss your matter, whether you're dealing with an insurance company that's just giving you all kinds of grief. Maybe you've been asked to appeal, and it can be just a quagmire of pain, panic, and strife. Don't sit back and let it happen. Reach out to James and his team. The number 1-855-821-5900. Keep that number with you. help@disabilityrights.ca. I'll give you some more contact information throughout the show, and we'll get to a main topic in our next segment after a break in just a bit. What you need to know about disability claim denials. That is on the way. Lots more and some phone call possibly from our radio show as well. But James, we want to start off with a case of the day, or a week that was, pal. What's going on?
Well, I always like to do some myth busting off the top. So one of the things that comes up all the time is the lack of objective evidence when someone's applying for long-term disability benefits and how that might be used by an insurance company. So this is very often going to be cited by an insurance company as the basis for a denial. They'll say, we've received your application, and upon review, there isn't any objective evidence that supports your inability to work. There's no objective medical support. They'll say it any number of different ways, but the bottom line is what they are saying is that there is nothing objective. There's nothing black and white. There's no x-ray showing a broken bone. There's no test showing repeated elevated blood levels. Whatever it is, there's nothing objective. And they say, okay, well, since there's nothing objective, your claim is denied. That's a crock, quite frankly. If you take a look at your policy, there is nothing in the typical long-term or short-term disability policy that requires objective medical evidence of anything, nor does it require a specific diagnosis. Now, having objective evidence, having a specific diagnosis is useful to understand what's going on and can help to persuade the insurer that you're entitled to benefits, but it is certainly not a requirement to get your benefits approved. And the courts have said this time after time. This isn't ambiguous. This isn't just my opinion. This is what the courts have said when they interpret long-term disability contracts. They say this over and over and over again. So what is required? You're required to show that you have a medical condition that's causing a functional impairment that is preventing you from being able to do your job. And it doesn't have to be one single thing either. It can be a combination of several physical things, or something physical and mental health or cognitive. Whatever it is, the combination of medical issues is preventing you from being able to functionally do your occupation. If that is the case, you're entitled to benefits whether or not there is a diagnosis, whether or not there's objective evidence. The reality is, we know that medical science advances over the years. If we were to say that it required a specific diagnosis or objective evidence, then certainly that would mean a number of mental health issues for lack of objective evidence would be denied. And going back a ways, because medical science has advanced over the years, a number of things that we're able to detect now wouldn't have been detectable 15, 20, 30 years ago.
Same in the future.
And if you were entitled to rely on that, you could deny it. All that's required is that you have a medical condition. And what does that mean? So I had a client who approached me. They were in excruciating pain for a long period of time, over 3 years. Didn't know what was causing it, and it wasn't for lack of trying to find out. GP had sent this guy to a gastroenterologist, internal medicine, general surgery, chronic pain specialist.
Wow.
Nobody could figure out what was causing it. Still don't know, by the way. No objective medical evidence was explaining what this condition was. The insurer, now this might surprise you, the insurer actually approved the claim, at least for the first 2 years.
Right.
Benefits were being paid for the first 2 years. Obviously, they agreed that, notwithstanding a lack of objective medical evidence, this guy was clearly disabled, was in just too much pain to be able to work. At the 2-year mark, they cut him off. Now, that's not uncommon. 2-year mark, the test changes to whether you are disabled from your own occupation to whether you're disabled from any occupation you're qualified for by training, education, or experience. What is surprising is the reason they cut him off at the 2-year mark.
Okay.
They cut him off because they said there was no objective evidence that he wasn't capable of doing a sedentary job, which, by the way, his own occupation was also sedentary. So all of a sudden, this lack of objective evidence is becoming an issue for them. Somehow now all of a sudden,
never was.
It wasn't before. They paid them for 2 years. And he appealed, and it was denied. And again, the denial was on the basis of a lack of objective evidence. So one, a lack of objective evidence is not a legitimate basis for an insurance company to deny your claim. If they are denying on that basis, you should not leave it. If your doctors are supporting that you cannot work, even if they don't understand yet why you are disabled, what the underlying cause is, that does not mean you're not entitled to benefits. If you have a medical condition, even if you don't know what it is, that's preventing you from working, you are entitled to LTD benefits, full stop.
And this rings true more and more that we've talked about recently with you and Tumarkin and the radio shows as well, that it's like with mental disabilities especially, they don't always show up. In fact, rarely, I would say. I'm not a doctor like you, but you know, x-rays, MRIs, CT scans, it's not a type of thing that's going to be, hey, look, James, here's objective evidence. But they're still incapable of working, right?
Yeah, I don't know if you meant to imply that I'm a doctor, but to be very clear, absolutely not a doctor. But yeah, you're quite right, John. You know, mental health claims are clearly covered under long-term disability policies, and in virtually all cases, there isn't going to be objective evidence of a disability in those cases, but they obviously are covered under LTD policies. Yeah. So it cannot be the case that objective medical evidence is required, and nor is it the case that it's required for physical issues. It's just not. The courts have addressed this, and time after time after time, they have said without ambiguity, objective evidence is not required for an LTD claim.
PocketDisabilityLawyer.ca. We mention that all the time. Before you know, James, even more before you make the phone call to James or a member of his team, you can go there, PocketDisabilityLawyer.ca. Run you through a quick assessment. It's nice because you can just do it in your own living room on your tablet or your desktop. At the end, it'll say, you know what, it looks like you should be reaching out to James for whatever particular reason. There's a phone number there, other contact information, really easy, private to use, completely anonymous as well and free. PocketDisabilityLawyer.ca. Now, I did mention, I think I mentioned shortly off the top that James and I and tomorrow, all of us do a ton of radio, have been doing it for years across the country. Hour-long shows, we talk about these matters all the time. We get great people calling in and having discussed their matters, educates everybody. We got a phone call from a recent radio show, James. I want to play it right now, and we'll talk about it.
My daughter was working in a supervisory role with a full benefit package. She's been sick now for maybe a year and has been off work. She went through and used her short-term disability. They told her to apply to EI, so she went on to EI and then tried to get onto her long-term disability, but they're saying because she doesn't qualify for it. So now she's basically been going for the last few months with nothing.
Not uncommon.
No, not uncommon at all.
No.
What is most interesting to me about this situation is this gentleman's daughter was approved for short-term disability benefits, but then denied for LTD. And this is an issue that comes up not infrequently, but it is really important to understand that short-term disability benefits, with one exception when you're talking about pre-existing exclusions, which isn't relevant here, other than the pre-existing exclusion exception, the test for short-term disability benefits is in substance the same test for long-term disability. Meaning, if you're approved for one, unless your condition happens to improve sufficiently before you're entitled to LTD benefits, you should also be approved for long-term disability benefits as well. It is, in substance, the exact same test. I don't know whether or not this gentleman's daughter has an LTD policy where the insurer for the LTD is the same as whoever was deciding whether or not she was entitled to short-term benefits. If it is the same insurance company that approved her claim for short-term and has now denied for long-term, they're in a very bad spot, the insurance company, because they're going to have to justify how all of a sudden, on the date she became entitled to long-term disability benefits, she was somehow magically no longer disabled, where she was all the way up to the end of the short-term disability period, which invariably ends the day before LTD starts. That doesn't make any sense. Now, it may be the case that it was some other entity, perhaps another insurance company or an administrative company that was adjudicating the claim for short-term benefits and a different company for long-term. And in that scenario, the long-term disability insurer is entitled to come to their own decision. And I suppose there could be a circumstance where the LTD insurer may come up with a decision that is different than the short-term insurer or whoever decided it. But there is certainly going to be a pretty good argument that she's going to be entitled. Obviously, there is sufficient justification for her entitlement to short-term disability benefits. So it suggests to me that it's very likely she's going to be approved. What can we do about it? Well, give us a call, and certainly we're going to be able to go through the medical situation and figure out whether or not this is something that's challengeable, and I suspect in this case that it would be.
Would a phone call from you guys sometimes in this case kind of shake them off? At least rattle them sufficiently that they're like, oh boy, that was a bad decision?
The insurance company?
Yeah.
No, honestly not. The insurance company isn't going to respond until they get a lawsuit.
Right.
That is really the only thing that makes the move. And the reason why you have to kind of pull back the yellow curtain a little bit. So when you're dealing with the insurance company at the application stage, what happens is your claim goes to the claims department.
Yep.
And that is populated by the claims handlers who have a particular objective. Their objective is to get rid of these as quickly as they can. That's what they're trying to do. They're trying to pay out as little as possible, and that's what the people in that position are there to do. And incidentally, if they're trying to suggest to you that they're there to help you or they're in some way your friend, they're not. They're not. Doesn't mean you should be rude to them, but keep in mind their job is to try and get you off claim as quickly as possible. They may be friendly about it, but they're trying to get you off a claim. So keep that in mind when you're dealing with them at all times, for sure.
We're going to take a short break. What you need to know about disability claim denials, that is on the way momentarily. But in the meantime, write down the number. Always call James if you have any questions. 1-855-821-5900. How you do that, and help@disabilityrights.ca for email as well. We'll continue with more of the Disability Law Show.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back, Disability Law Show. Thank you for hanging through that short break. John Scholes here, James Fireman as well. You can always reach out after the show anytime. Phone number? Sure, 1-855-821-5900, help@disabilityrights.ca. That's the email address we're going to go to very shortly, and disabilityrights.ca will take you to the firm website and more contact information and goodies there as well, stuff you can read up on and educate yourself on your own time. But James, main topic, it's a broad one, what you need to know about disability claim denials. This is for you as well, of course. The first thing is insurance companies often deny disability claim benefit claims despite the support of your treating doctor or doctors, right?
This is almost certainly the biggest source of frustration for people who are going through the LTD process.
Sure.
They have some medical condition that is preventing them from working. They go to their doctor and their doctor says, yeah, you shouldn't be working right now. You should go off work. And they're not able to resolve the condition, and they apply for long-term disability benefits with the support of their treating doctor, who is certainly the person most familiar, the medical person most familiar with what's happening with them. And the insurance company says, no, we don't think you're disabled. That doesn't make a lot of sense. It really doesn't. There isn't a lot of logic there. The person in the best position medically to make that determination is always going to be the treating doctor, or perhaps the treating specialist if it's a condition that requires specialized medical expertise. But as long as you have support of those medical professionals, there really isn't any logical basis for an insurance company to say that you're not disabled, and yet they do, frequently. They come up with any number of different justifications for doing it, but very rarely is whatever justification they come up with going to be sufficient for a judge, if it ever went to court, to say, actually, the treating doctor was wrong and the insurance company is right, and you're not disabled. When there is a treating doctor that is saying that you are disabled from work, that's enough for me to go ahead with the claim. And I know insurance companies are going to come to the table as soon as we bring the lawsuit, because ultimately they understand it's going to be enough for a judge as well. If the treating doctor is saying that you're disabled, you are. Doesn't mean that you're going to get approved. Doesn't mean your insurance company is going to pay out the money that they ought to. But it means that they should be paying it. And if they don't, then you have a really good basis for challenging the denial.
Is it almost a blanket response? Like, not, in your experience, 9 out of 10 people who applied to say, no, we don't. You don't have the medical support, the treating doctor. We don't believe it. You're not disabled enough.
I wish I could tell you it was 9 out of 10. It might be more than that. It might be less than that. I don't know. And the reason I don't know is the insurance companies don't
really
publish those numbers. And they won't for a good reason. They don't want people to know. And the reality is, and to be very fair about this, the people who are contacting me are a very particular subset. They are the people who have been denied their claims. Sure. So I don't know how many people have been approved first. Right. But the reality is, so many of the people that are contacting me with very clear medical conditions that are unambiguously supported by their doctor. And the insurance company denies the claim and says that they know better. Why? Because they've gotten some family doctor who hasn't ever assessed you to review a couple of the medical documents and say, no, they can go back to work. That's typically the basis for it. It's very rarely anything more than that.
That's so damn frustrating for the doctor, your medical team as well. They're probably like, what else do I have to write to convince this insurance company? I just said you can't work. This is the degree on my wall states that you can't work. I mean, can you help doctors out? Not coach them on what to say. Obviously, you're not a doctor. You always say that. But if they come to you saying, James, what else do I got to do? Am I not filling this thing out correctly?
100%.
What's going on here?
So one of the things that I recognized very early when I started doing long-term disability is that doctors are generally not well equipped to deal with long-term disability claims because it's just not something that they're ever taught. Yep. People do not go to medical school saying, one day, I want to help people to get their LTD insurance.
That's right.
They want to help people to make their lives better, to make them healthier, to fix their medical problems. The insurance is the nuisance part of it. It's the part that they don't want to do. Totally understandable, by the way. Yep. I have all the sympathy in the world for doctors who don't want to have to deal with insurance companies because, my God, they are frustrating, and that's not what they went to school for. But it is, unfortunately for doctors, that is a part of what they're required to do. And it is something that I'm always happy to help doctors with, whether or not, by the way, their patient is my client. I'm always happy to talk to a medical professional who is engaged in the LTD process or the disability process at any level and is really unsure how they are to complete the form. And I'm not suggesting for a moment that I'm going to tell a doctor, oh no, you should say this and you should say this and this is what your opinion should be. I'm talking about making sure that the doctor understands what the focus of the inquiry is, what their attention should be directed at, and what questions they need to answer. It's always going to be the doctor's opinion. I would never try to tell a doctor what their opinion should be. I would simply tell them, this is what opinion you need to address. Right. This is what the insurance company needs to understand in order to determine one way or the other. This is how you can help your patient.
Nice. What we're talking about is what you need to know about disability claims. Number 2 is this, James, the denial of benefits doesn't mean you're out of options.
Yeah, you know, the insurer is going to, when they deny a claim, they send you a letter. And the letter is going to say, well, your claim's been denied, but if you disagree, you can appeal. That's what they're going to suggest to you is the option. Not only is that not the only option, it's also the worst option available for you. The other option is to contact a lawyer and start a lawsuit, start a legal claim. And the reason that is so powerful is because it takes the process out of the hands of the insurance company. The appeal is not some official process that has rigid rules and timelines. It is something the insurance company has made up as a way to try and convince you not to contact a lawyer, not to bring a lawsuit, not to take the decision out of their hands. As soon as you bring a lawsuit, it's in the court system. They are no longer in control of that process anymore. And that is the thing that they fear the most, and for good reason, because they know if it ever winds up in front of a judge, they're going to be in big trouble in most cases, which is why when you start a lawsuit, they come to the table very quickly. Even though there are many long-term disability cases that are out there, very, very few of them ever wind up in court. It's usually a small handful each year, maybe 5 or 6 across the country.
Plus, sidebar, once they start a claim with you, the phone calls stop, the emails stop because they can no longer contact you, which is, half of your treatment already. I joke about this sometimes. I say to my clients, particularly those that are suffering from anxiety, that
when that happens, when we start the claim and the insurer is no longer able to contact you, it does actually make your life easier. Now, I'm not suggesting that starting a lawsuit is the cure for your mental health issues. I'm not suggesting that. But I will tell you, it is quite frequent that I hear from my clients that that was the biggest thing for them, is just not having to deal with their insurance company anymore, getting that weight off of their shoulders. And that's why people call me. No. They call me because they don't want to deal with their insurance company anymore. And guess what? Once we're retained, you don't have to deal with them anymore. That's what we're there for. That's what we're hired for.
It's like when your mother-in-law goes on vacation. She has no access to a phone for a week. Look about it. You feel better about yourself. Did I say
I love my mother-in-law, and I'm always happy to hear from her.
There we go. Nice. Very smooth. Third one, this, pal. What you need to know about disability claims. You have up to 2 years. A lot of people don't realize it. 2 years after the initial denial to file that claim.
Yeah, this is a really important piece of information for everyone to understand here. There are two different timelines that are in play when you're in the LT process. One is the application timeline. That can vary to some extent, policy to policy. Sometimes they say 60 days, sometimes 90. It's typically somewhere in that range. But if you happen to miss the application deadline, it's not usually the end of the world. Typically speaking, the courts will tell an insurance company that refuses to accept a late application that they have to do it, as long as it's not 5 years after the fact, as long as they are not prejudiced from being able to properly adjudicate the claim because it's been too long. And particularly where the person has a reasonable explanation. They didn't understand that that was a timeline, or their medical condition prevented them from being able to apply, what have you. Courts find that that is sufficient reason. It's called relief from forfeiture, if you need to know. But typically speaking, that particular deadline is not one that's very strictly enforced. Now, I'm not suggesting that you should dilly-dally and let that timeline expire. If you can apply within the timeline, certainly you should. But it isn't the end of the world if you've missed it. Apply right away, and if they challenge you, we can help you in that scenario. The other timeline is far more rigid, and that is the 2-year limitation period. And this is what applies from the date after you have first been notified that your claim has been denied. So typically speaking, when you're denied, as I mentioned, they're going to send you a letter in writing, and they'll have a date on it. 2 years from that day that they notify you that your claim has been denied or that your benefits are being cut off, even if they're telling you your benefits are being cut off at some date in the future, 2 years from the date that you are notified that your claim is being denied, you will no longer be able to bring a lawsuit to challenge that decision. And so it is really important that as soon as they tell you that this is happening, even if they tell you it's happening several months in advance, which sometimes does happen, you want to contact us right away, and you want to get it started as soon as possible, because the legal process does take some time. It's typically somewhere around 10 months, 10 to 12 months. If they're giving you 5 or 6 months notice that they're going to cut off your benefits down the road, if you start your claim now, that means it's going to get resolved within a few months of the date they cut you off, which, although it's not great that you're not getting the benefits for those few months, most people are going to be able to keep their head above water. It's much more difficult if you wait until the benefits run out and then start the process. Then you have to go through the entire 10, 12 months without getting any benefits. It makes it much more difficult. So if you're in that situation, if your insurance company has told you that they're cutting off your claim, or that they're doing it at some point down the road, or they're denying your claim, you want to give us a call right away. And certainly you want to make sure that you are making that decision well within that 2-year limitation.
All right, short break. We got time for an email or two, so stick around for that. It may be your email if you've sent one along. Any other time, you can do it. help@disabilityrights.ca, and that phone number, 1-855-821-5900. This is the Disability Law Show. We're coming right back.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back, Disability Law Show. Thank you so much for hanging through the break. Let's tuck into an email, James, before we wrap up for this particular week. For you anytime, by the way, help@disabilityrights.ca. Mina writes in, says, almost a year on long-term disability. I was informed by my company's HR department that they were shutting their doors and I was being let go. I'm not sure how this will affect my benefit payments. Is there anything I should be aware of?
The good news for you, Mina, is you should be perfectly fine. So there's two things that we need to talk about here. The first is what happens in terms of your coverage, your LTD coverage. And that's something that a lot of people are going to be concerned about because they're thinking, okay, well, my company's out of business now, and they were the ones who were providing me with this insurance policy through my employment. The reality is that once you go on a medical leave, your coverage is crystallized at that point. And you are entitled to ongoing benefits as long as you remain continuously disabled throughout. So as long as there isn't a point subsequently where you are capable of returning to work, you're going to continue to be entitled to receive those monthly benefits up until age 65, when you would have been anyway, regardless of the fact that your employer is no longer in business. Now, there is one other aspect, though, that you do need to be aware of, because typically speaking in this scenario, often there's going to be some sort of termination pay, severance pay. And again, I'm not the employment lawyer, but we do see that happen often when companies shut their doors. And where that happens, most policies are going to have a provision that says that the insurer is entitled to an offset for the period of time that you're getting any income, and severance and termination pay would be deemed as income under most policies. But it doesn't necessarily mean that the insurance company is entitled to offset the entire amount of what you're being paid. It's only for the period that you are getting paid. So for example, if your typical LTD payment was $3,000 a month and you were earning $5,000 a month and you got 4 months worth of severance, so 4 months would be $20,000. The insurer isn't entitled to offset the next $20,000. What they're entitled to do is offset during those 4 months. Now, it would be the entire amount during those 4 months, but it's only the $3,000 of benefits that they would be paying during that time.
The other $2,000 they can't touch.
That's right.
Nice.
So during those 4 months, yes, your insurance company would be able to offset that money, but they would not be entitled to get the full $20,000. So if you are getting severance or termination pay, you want to keep that in mind, because that will be something that you're going to have to account for, but it's not a total loss. And in any case, once that termination period, once those payments are expired, you're entitled to continue receiving your benefits after that, as long as you continue to be disabled.
So basically, the insurance company, completely different entity from your employer, even though the employer, when your contract, when you got the job, includes your benefit package with long-term, blah, blah, blah. Different entity. So once you're on their tracks, don't worry about the employer, really.
Yeah,
right?
As soon as you are disabled, as soon as you go on medical leave, your coverage is crystallized at that point. It doesn't matter whether your employer goes out of business or even if they fired you for some reason, you're still entitled to your benefits going forward, subject to those offsets that we talked about.
Interesting. I mean, you mentioned putting on your employment lawyer hat there for a moment. Shutting down, if they're bankrupt, there's not going to be any severance, so they're not going to get a piece of anything, really. Possibly.
Presumably. Yeah. Now, I don't know, I suppose it's different depending on the particular circumstances, but if you happen to not get any severance, then you don't have to worry about the offset. Hopefully, it's a problem that you have to deal with, because at the very worst, it means that you're getting slightly less overall, but you're still getting the extra $2,000 a month that you would get.
You got it. Mina, nicely covered. Really appreciate you reaching out with that email. You might want to follow up with a phone call. That is anytime your priority, your option to do so. 1-855-821-5900 to do that for you as well if you've been watching. That email address we always use is help@disabilityrights.ca. And any other information, you can go to disabilityrights.ca, the firm website. You can catch one of our radio shows across the country and phone in, and maybe your phone call will appear on a future show. Thank you so much, and we'll catch you next time on the Disability Law Show.